Please join me in welcoming Paula Gerber.
Thank you very much. When we talk about gay rights in the Western world, this is what a lot of people conjure up. And we need to recognise that Australia and other Western countries are in a very privileged position, that our debate about gay rights has been elevated to this level of marriage equality, because in many other parts of the world, when you talk about gay rights, it's the right not to be beaten, not to be jailed, not to be killed for being gay. And so what I want to look at today is what's the UN doing about these sort of atrocities. And they are widespread. There are actually 78 countries around the world where same-sex sexual conduct between men is criminal. 5 of those countries, it's actually can be subject to the death penalty. And a beautiful legacy of the British Empire is that of those 78 countries, 42 are Commonwealth nations. So I think that Australia, as part of that Commonwealth, should be paying attention to reform in this area. And it's important to recognise that these are not just laws that are on the books, that are not being prosecuted. And I've put up there a couple of recent examples of people who've been jailed for extended periods of time simply for being gay. So the first case in Cameroon, where a gentleman sent a text message to another man that says, "I think I'm very much in love with you." That got him 3 years in jail. And a couple in Malawi who had an engagement ceremony, they were both given 14 years imprisonment with hard labour. So what is the UN doing about this? Now, initially I took the rather ambitious idea that I could look at the UN as a whole doing this, but I think that would require a whole book rather than just a conference paper. So I've narrowed it down to the Human Rights Committee. And the reason I chose that body is because I think the ICCPR has a very important role to play in combating persecution and violence against gays. But also because I think it's very worthwhile to look at an expert body, 18 human rights experts, rather than one of the political bodies within the UN like the General Assembly or the Human Rights Council, which can be subject to political influences rather than just looking at the law. So I've narrowed down the work of the Human Rights Committee, or what I'm going to look at today, into 3 distinct components. The concluding observations that follow periodic reviews of states' compliance with the ICCPR, the general comments that the committee has published, and finally their decisions on individual communications, which is still a fairly ambitious task in 20 minutes, but we'll see how I go. So let's start with concluding observations. Why concluding observations? Well, they have been elevated to the primary record of the findings and recommendations regarding each state party under review, and they constitute an important interpretive tool for the respective treaties. But nevertheless, it has been observed that there remains considerable scope for enhancing the concluding observations and the follow-up procedures. But what I've done is taken 10 years worth of concluding observations, and that's a fairly detail-intensive task, and I'd like to thank Joel Corey, who was my research assistant in helping me going through all of this data, because it's 136 states that were reviewed, of which 45 of the concluding observations related to LGBT rights. So it's very illuminating to see, well, what's the Human Rights Committee's view on these issues? And their comments in these 45 cases, 45 concluding observations, tended to fall into 2 distinct categories. The first was the anti-discrimination measures, and I've put up there the sort of things that they were focusing on. But the second, which I think is perhaps the most grave situation, is the criminalisation of homosexual conduct. So we can look at these concluding observations in 2 ways, the quantitative analysis of the data and the qualitative analysis of the data. So let's start with the quantitative analysis. And what we see is that early on in this decade that I'm looking at, from 2003 to 2013, we see that 15 states were reviewed in 2004, but only 4 of them generated comments on LGBT rights. some 9 years later, 15 state parties again reviewed, and this time 12 of the concluding observations contained references to LGBT rights. So just on that rather simplistic measure of the number of times that LGBT rights are being mentioned, we can see that over the 10-year period we've seen quite a significant increase. But I think the more interesting component comes from the qualitative analysis of the concluding observations. And during this 10-year period, there were a number of states that were reviewed twice. And so it's really insightful to look at, well, what was the comments made at the initial review early in this 10-year period, and what was the comments made later in the period. And I've pulled out there as an example the Philippines. We can see that in 2003, a very brief, non-specific, rather vague comment that they needed to adopt legislation explicitly prohibiting discrimination. But in 2012, significantly more in-depth analysis. So they made reference to the Ang Ladlad case, which was a gay and lesbian political party that was denied registration as a political party on moral grounds. And the committee was highly critical of that. They talked about the provisions under the Penal Code and the anti-discrimination legislation. So we see that there's significantly more depth to the analysis that took place later in that decade than earlier. And I think it's really important that we want the committee to be making these sort of in-depth analysis, because the more detailed focus and actionable items that they refer to, the more likely that the state party is actually going to be able to respond to those recommendations and to report back on them at the next review. The second point that I want to make regarding the quality of the concluding observations relates to the language being used by the committee. Very early on, the language was homosexuals. That then changed to sexual orientation, and in 2009, we see that the dominant terminology being used is LGBT rights. And this is a significant change. It's a much more appropriate terminology to be using, and at the same time we see that they're also bringing in other specific language like gender identity, and even in 2012 references to intersex. Unfortunately, the use of this language is not always correct or appropriate. For example, when referring to transsexuals, they've made references to sexual orientation rather than gender identity. So there's still work to be done, but we are going in the right direction. You'll recall that I said that the comments tended to fall into two categories, the anti-discrimination and the decriminalisation. Let me talk now for a moment about the decriminalisation, because in this 10-year period there were 31 states that had laws that criminalised homosexual conduct. Only 13 of those 31 states had any remarks made about the fact that they still criminalise same-sex conduct between men. So that's less than half of the states. So if we take two states reviewed in the same year, Togo has criminal laws carrying a punishment of 1 to 3 years imprisonment. The Seychelles have criminal punishment of up to 14 years imprisonment. Togo received criticism from the Human Rights Committee. Great. Seychelles did not. What's the explanation for this very inconsistent approach to states having criminal laws regarding same-sex conduct? The explanation seems to reside in the shadow reports. One country, the shadow reports highlighted this aspect of the criminal law and called on the state to repeal those criminal laws. In the other state under review, the shadow report was silent on this issue. So if civil society needed any encouragement that their reports are making a difference, that they do get noticed at the committee level within the UN, that is a classic example. The fourth point that I want to make in part of my qualitative analysis is the lack of specificity and actionable recommendations. The Human Rights Committee tends to make very general non-specific comments. So you need to provide effective protection of LGBT persons. You need to launch a campaign. That's not really a targeted, measurable action or recommendation that a state can act on. And what we also see is the use of generic language. It's like they've got a cut and paste person there who goes, oh, that was a good comment that we put in this report, let's repeat it in another report. Now, I recognise that they've got a large workload that they have to manage and get through, and maybe using the same language from over and over again helps manage that workload, but it really is a missed opportunity to give the state some clear guidance on what they would like to see changed by the next time they come up for periodic review. So, to conclude on my concluding observations, there are, over the 10 years, some positive aspects. We're seeing increased references to LGBT rights, we're seeing increased depth and detail in some of the observations, like the Philippines, and we're seeing greater use of more precise language. But at the same time, there are some negative aspects, and that is, I think, that the number one is the failure to consistently deal with the issue of decriminalisation of same-sex sexual conduct between men across the various states, and they need to adopt a more comprehensive and nuanced treatment of the breaches that are seen coming before the committee. So let's now turn to the second aspect of the committee's works that I want to look at, which is general comments. These are, of course, interpretive statements, documents published by the committee to give guidance to state parties about what the various provisions in the ICCPR mean. And Otto, my former PhD supervisor, has said that they are quasi-judicial and carry enormous political and moral weight, and they've also been referred to as similar to the highly influential advisory opinion of tribunals. So they're really important documents. They don't amount to law as such, but they certainly carry a lot of weight. And over the many years, the various treaty bodies within the UN have published more than 100 general comments, and the Human Rights Committee has been the most prolific. They've published 34 general comments. But how many of the Human Rights Committee's 34 general comments have made any reference to LGBT rights? The answer is a big fat zero. And it's not as if there haven't been opportunities for the committee to comment on these rights. Certainly other treaty committees have found opportunities. If we compare the treaties, we see that the Committee on Economic, Social and Cultural Rights has been the best in this area. They've published 5 of their general comments have made reference to LGBT rights. The ones we're probably most familiar with is General Comment 20 that said that the other status in the discrimination provision includes sexual orientation. And some of the general comments that the Human Rights Committee could have usefully included LGBT references in were the 1989 general comment on discrimination under Articles 2 and 26, although I do acknowledge that in 1989 the awareness and conversation around gay rights was not at the level that it's at now, and that may have been a bit ambitious to expect that back then they would have addressed this. But more recently there have been general comments 28 and 31 where I think they could have very easily incorporated LGBT rights into those general comments. Things may be changing though. After 32 years of silence from the Human Rights Committee on this issue, we now have draft General Comment 35, which is focused on Article 9, Liberty and Security of Person. And it provides that the right to security of person in Article 9 obliges state parties to take appropriate measures to protect individuals, whether detained or non-detained, from known threats to life or bodily integrity proceeding from either governmental or private sources, and states must respond appropriately to patterns of violence against categories of victims, such as violence against sexual minorities. So we're finally seeing that maybe there is going to be a movement from that baseline of 0. And the approach seems to be to put sexual minorities' rights within the bigger framework of the human rights conversation. And this is the approach that Ignacio Saez has said has been contributed to the success of the European Union in increasing their focus on LGBT rights, where the penetration has been significantly more than within the UN. As I said, this is a draft general comment that started discussion at the 107th session in March of this year. It will continue at the next session, and all that we can hope is that in the ongoing drafting and revision of this general comment that this reference to sexual minorities doesn't get dropped along the way. So, to conclude on my discussion on general comments, there is certainly significant room for improvement in this area, both in feeding in LGBT rights into general comments, and also I would suggest that it is time for the Human Rights Committee to consider drafting a general comment specifically relating to sexual minorities. They've done a general comment in relation to other minorities, cultural, religious, linguistic minorities, and I think it's time for one on sexual minorities, and that's perhaps most starkly evidenced by one state party who, in its review before the Human Rights Committee, made the comment that there was no reference to transsexuals in the ICCPR. The inference being, well, if the ICCPR doesn't refer to transsexuals, then obviously they're not covered by it. So the final aspect of the committee's work that I'd like to look at is the decisions on individual communications. And over the years there have been 5 decisions on individual communications relating to sexual minorities, the first 2 against Australia. And I might take just my remaining time to have a quick look at those decisions. The landmark case that Mark Dreyfus mentioned in his presentation this morning of Nick Toonen really has made an enormous contribution to the jurisprudence in this area, because the committee found that the Tasmanian laws criminalising same-sex conduct, sexual conduct between men, violated both Article 17, the rights of privacy, but they also very importantly said that the reference to sex in Article 26 on non-discrimination included sexual orientation. And the leading authors on the ICCPR, Joseph, Schultz and Castan, have noted that the Human Rights Committee was clearly influenced by the fact that all other Australian states had repealed such laws, and there was no consensus regarding the appropriateness of the laws in Tasmania. This decision indicated that the ICCPR could potentially be interpreted in a relativist manner. Perhaps similar laws in a different state with no comparable record of tolerance and acceptance of homosexuality would survive a similar challenge. But they also note that since the Toonen decision in 1994, the Human Rights Committee has clearly exhibited disapproval of cultural relativist arguments. So it was about a decade later, I think we are, yes, we're coming up to the 20th anniversary of the Toonen decision. A decade later that Australia was again under the microscope of the UN Human Rights Committee, this time in the case of Edward Young, who had been living with his partner 38 years. He was a former soldier, and when he passed away, if it had been a heterosexual relationship, he would have been entitled to a veteran's pension under the Veterans Entitlement Act, but that provision was limited to heterosexual couples. And the committee, citing the Toonen case, says Mr Young has been discriminated against by the Australian government in violation of Article 26, because that discrimination is based purely and simply on his sexual orientation. And that decision in Young and Australia was one of the catalysts for the sweeping law reform that we saw. I think 86 pieces of legislation were amended several years ago at the federal level to remove all references to heterosexual couples and to discrimination against same-sex couples. X and Colombia was a very similar scenario where X's same-sex partner of 22 years died. He applied for his partner's pension to be transferred to him. Colombia's law said no, that's only available to heterosexual couples. And I think Colombia's argument I found rather interesting. They said, look, this is designed to protect heterosexual couples. We're not trying to harm homosexual couples. It's just, it doesn't apply to them. And once again, the committee, citing earlier jurisprudence, said, no, that is a clear breach of Article 26. The black mark in the jurisprudence from the Human Rights Committee is the decision in Jocelyn and New Zealand. Two lesbian couples took a complaint to the committee that they were not allowed to marry under the New Zealand Marriage Act, and they brought the complaint under 4 provisions. Article 23, the right to marry; Article 16, recognition as a person before the law; Article 17, privacy; and Article 26, non-discrimination. And the committee basically refused to consider the case under Article 26. They said we've got a very specific provision under Article 23. It refers to marriage as being between a man and a woman, and therefore we don't have to consider any of your other alleged violations under the ICCPR, because we find that the more specific provision under Article 23 overrules all the more general provisions, including Article 26. I suspect the Jocelyn decision is a product of its time. It was probably brought prematurely. When it was brought, only one country in the world had legalised same-sex marriage. That was the Netherlands just 1 year earlier. And I think the committee just wasn't ready to tackle this sort of issue. Now, some decade later, we have 15 countries where same-sex marriage is legal, including, of course, New Zealand itself. And I suspect that over time we will see that Article 23 on marriage will come to be interpreted through the lens of Article 2 and 26. The final decision, quite recently, a 2012 case where a lesbian erected a couple of signs that said homosexuality is normal and I'm proud of my homosexuality near a secondary school. She was prosecuted and fined for promoting propaganda of homosexuality among minors. The committee, in a very welcome decision, said you're not saying that it's a problem with talking about heterosexuality or anything else. It's only homosexuality, and that is clearly a violation or discrimination of Article 19. It's got to be read in conjunction with Article 26, which is the point they refused to make in Jocelyn. Where I say epic win, I should point out that that is an epic win in terms of international law and the jurisprudence of the UN Committee. Anyone following the news in this area would know that the situation for LGBT persons in Russia is still very dire, and prosecutions and convictions are continuing. So that state party is not really taking much notice of the UN Human Rights Committee work in this area. So the conclusion regarding individual communications, well, the scorecard is 4-1, so I think that's a pretty good decision, and I think it's an area where the committee is doing some great work. I'm an academic. I'm used to assessing students' work and giving them grades, so I decided to do the same to the Human Rights Committee. Their report card looks something like this. Concluding observations, I give them a B+. They need to work on concentration and consistency. General comment D, I really probably should give it an F, but that draft general comment 35 gets them up a little bit. And individual communications, notwithstanding the decision in Jocelyn, I give them an A. Thank you.